Okay, I think we're ready to go. Good afternoon, everyone. My name is Stephanie Bowe. I'm with the Louisiana State Bar Association, and welcome to our Law Talks virtual workshop series. This week is our Lawyers and Libraries Week as we join in the American Bar Association in their National Celebrate Pro Bono Week. And so we'll be presenting a Law Talks every weekday at noon throughout this week. Today's Law Talks is on bankruptcy, and we have attorney Jenny Abshire with the Big Easy Law Group presenting on this important topic. Okay. But before we get started, there's a few things I need to go over, a few important reminders. First, this presentation is being live streamed, and questions will be taken at the end if time permits and answered live. If you are watching at a library, you may walk up to the computer and to ask or to submit your question through the library staff. If you're watching by Zoom, please submit your questions in the Q&A section. And if you're watching live on Facebook, please submit your questions in the comments section. Please remember all comments are public and visible during and after this presentation. Also, please keep your questions general and not case specific. The attorney can provide information about the law and the legal process, but they're not giving legal advice on individual cases. Also, please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking advice from legal counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, you can go to the Louisiana Civil Legal Navigator, which is listed on this page, and we'll talk more about that later. The LSBA's inclusion of a program is not deemed to be a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentation or materials were free of errors or will continue to be accurate. Statements in the presentation and the materials should be verified before relying on them. Opinions are expressed are those of the speakers and do not necessarily reflect the opinions of the LSBA, its section, or committees. Views expressed are those of the authors and contributors only. Oh, I just got notice. I think we're having a technical issue with our Facebook Live event. So I'm going to pause right here real quick to try and to see if we can get reconnected to the Facebook Live event. Let's see. Okay. I think we're back up. All right. Again, I apologize for the technical delays. It's Monday. I think it's just going to happen. But let me reshare the screen. Slides. Okay, there we go. Okay, let me try one more thing. We're getting another notice that it's not live streaming. Jenny, I'm very sorry. Viewers, I'm very sorry. We're gonna try and fix this. Okay, I think we're good. So we're going to go on to the next slide. We just went over all these disclaimers, which I'm not going to read again, but please refer to them. And as I mentioned, we have Jenny here to present on bankruptcy for us. And so Jenny, I'm going to go ahead and turn it over to you.
All right. Hi. Well, thank y'all for choosing me to do this. I think this is a really great thing that the bar does. And, libraries are such a great resource. As a bankruptcy attorney, a lot of our clients have to go to the library just to be able to send us things and give us the documents that we need. So I think it's a really great thing that we're doing. So just to briefly introduce myself, I've been a consumer bankruptcy attorney for 14 years. I really found my passion doing this type of work, so I really enjoy it, and I welcome any questions that y'all have as we go through this presentation. Right, so why bankruptcy? What is bankruptcy? People don't usually know a lot about it. They just think, oh, people just file and get rid of their debt. But the definition we always look to is that it gives the honest but unfortunate debtor a new opportunity in life and a clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. That's something that we really hold dear because it's not designed to be a system to, just willy-nilly get rid of obligations. It's here to help you and get you back into commerce and get you back into life. And I always thought it was neat. The root of bankruptcy comes from banco rota, which means broken bench, which is what they actually used to do when people didn't pay their bills. But we don't break any benches anymore. So what I want everybody to keep in mind as we go through this, bankruptcy is a powerful federal law. It's a tool, it's a resource, it's a protection. It's here to help you to give the honest debtor a fresh start or an opportunity to reorganize their debts. No one passes judgment. This is just a legal process. It's just paperwork. Now, do keep in mind, bankruptcy is a great tool and it's really good at helping people. Doesn't take care of everything. Not going to get rid of child support obligations, doesn't get rid of student loans for most people, and a lot of recent taxes don't get wiped out either. If you have a specific type of debt that you're concerned about, I always recommend reaching out to an attorney. So we're going to start this very basically because people don't know exactly who are the players in bankruptcy. So it's important to know who is involved. So obviously there's you, the debtor. Cases can be filed by an individual or a married couple, and you are the debtor. The other parties are your creditors. You want to make sure you list all of your creditors in your case. They'll all get notice of your bankruptcy and be able to participate. The court is also going to appoint a trustee in your case. No matter which chapter you file, you're going to have one trustee. That trustee is appointed to basically administer your case. They're going to review all of the documents that you file with the court. They're going to handle your creditor meeting or your 341 meeting, and we'll get more into that later. If it's a Chapter 7 trustee, their job is to review all of your documents, review all of your assets. If there are any assets or funds that need to be administered, that's their job, and they're going to do that final accounting. In a Chapter 13, that's the repayment plan type of bankruptcy, the trustee is in charge of taking those payments every month, making sure your creditors are paid, and then at the end of the case, making sure that your discharge is there. And finally, the most important, the bankruptcy judge. That's who's going to oversee everything. The majority of consumer debtors will never interact with the bankruptcy judge. The judge is really only there to settle issues that the trustee can't handle on their own. So once your case is filed, every case proceeds the same way. Bankruptcy really doesn't have a lot of fluctuations besides the different debts people have and how things may be handled in specific circumstances. But the majority of cases go through the same few steps. The first one is filing your petition. When you file your petition, we're filing all of your schedules. That's the list of all of the assets you have, the list of all of the debts you have. Basically, everything that the court needs to know about you is going to be in those schedules. We also have a mandatory credit counseling class that has to be done prior to filing. These classes are typically done online. I think the first class is supposed to take somewhere between 30 minutes and an hour, depends on which credit counseling group you use. Most of the courts do have an approved list of credit counseling agencies that can be provided to you upon request. But when your case is filed, that's the first step. Your counseling class, your petition and schedules, and you have filed. You get your case number, you are in. The next step that people have to do is their creditor meeting. It's usually about a month after your case is filed. The majority of courts now do them by Zoom. And this is when the trustee is going to verify with you that everything is true and correct under oath. The next step in your case is your second counseling class, also called your financial management course. This, again, just like the first course, is going to be done online, anywhere between 30 minutes to an hour. And they're going to give you a certificate for that. Once you have your certificate and once the amount of time that is required has passed, you will be eligible for discharge. So Chapter 7 discharges are typically 60 to 90 days after that creditor meeting. Chapter 13 discharge is going to be after the completion of your planned payments, which can be anywhere from 3 years to 5 years. So all cases follow that pattern unless something is truly unique and exceptional. All right, so going back to that meeting of creditors, that really is, for the majority of people, their only interaction with the court. Like I said, they are typically by Zoom. I do think some jurisdictions do them in person. You can find all this information out on your particular court's website, and I do have those listed later on in the materials. The trustee is not the judge, the different person. So this isn't actually an in-court, hearing. This is a Zoom call, and it's a video call in most cases, and they're just there to verify that you are who you are, compare your ID to your video, and make sure that everything is true and correct. These meetings typically, in my experience, take between 5 and 15 minutes. There are usually multiple debtors on the same call being called up one at a time with their counsel, and they're pretty basic questions. Did you read and sign the petition and schedules? Is everything true and correct to the best of your knowledge, information, and belief? Did anyone help you fill out these schedules? What did you agree to pay your attorney? What is the address of your employer? Pretty basic things that you've already disclosed in the petition, so these are usually pretty uneventful meetings. Now, creditors do have an opportunity to appear at these meetings if they wanted to ask you questions about their particular debt. In the majority of cases, we do not have creditors appear at creditor meetings, especially in Chapter 13 cases, because there's a Chapter 13 plan that explains to the creditors how their debt is going to be treated in the plan. They really don't typically appear. They may appear in a Chapter 7 meeting if they have questions about their collateral or what's going to happen to their debt. So when we think about your creditor meeting and when we think about preparing your schedules, there are a lot of documents that we need to verify that everything is true and correct. You always have to be able to turn in and furnish your valid ID and social security card. You have to have proof of your income. Not everyone has the same income. A lot of our clients are on disability. Some of our clients are on retirement. Some people get paychecks. They get paychecks every week, every other week, once a month. Or some people are self-employed. Whatever your proof of income is, we need to have some sort of proof of it so that we can show the court exactly what your income is, so that we can make a determination of, one, which chapter of bankruptcy you're going to qualify for. But two, if you do qualify for, a Chapter 13, how long does that applicable commitment time period have to be? Is it 3 years or is it 5 years? You also have to turn in your tax returns. Tax returns can be requested for up to 4 years. We do want to make sure that you filed all of your returns and are current on your tax returns. If you own vehicles, we typically also need proof of your vehicle registration, proof of your insurance, and also usually a value on your vehicle. We need to know, what is your vehicle worth? We usually can get this from online. We need to have your registration and your mileage so we can make sure we're getting the most accurate value for your schedules. We also need bank statements. The trustee, especially in Chapter 7 cases, is going to look through your bank statements to see where your money's going. And in a Chapter 13 case, we also want to review your bank statements to make sure that we're giving the best estimate for your expenses going forward. If you have any domestic support obligations, like a child support order or alimony, you want to make sure you have a copy of that order to furnish to the court as well, so you can show what that obligation is. Now, sometimes people have additional issues. Maybe you have a collection suit or a wage garnishment. You want to make sure you have a copy of that ready to give to your trustee or attorney. If you have any retirement or investment accounts, you need to be able to show the account statements for those to show how much that asset is worth. If you do any tithes or donations to charity, depending on how much you give, you may want to get a statement from that organization to justify how much money you give, especially if you intend to continue giving those tithes throughout your bankruptcy case. Another important thing to keep in mind is proofs of transfers. Have you traded in a vehicle recently? Did you donate a car to a family member? If you have any of these things, you want to make sure you have the documentation to substantiate it. Also, for a lot of our clients, they will just give us a bunch of bills. You've got a lot of collection letters, bills, notices from creditors, and you're not really sure which one is a repeat or a duplicate or a third-party collector. It's always good to put all these things together in one place so that you can really review them and make sure that you're listing all of your creditors. If you have any residential leases, timeshares, or anything like that, you want to make sure you have that attorney or that paperwork ready for your attorney or the trustee. And also, if you're on a wage garnishment, you want to make sure you have your payroll information handy so that you can furnish that to the court or to your attorney to make sure that any wage garnishment is stopped as soon as possible. And if you're sitting there going, well, why would they stop the wage garnishment? That is the reason people file bankruptcy. It's the automatic stay. It's the most powerful tool in bankruptcy, and it's exactly why people file bankruptcy besides the ultimate discharge of debt. When you file bankruptcy, as soon as your case is filed, the automatic stay comes into place. The automatic stay will stop all collection efforts against you. If there is a pending foreclosure sale, even if it's tomorrow morning, if there is a tow driver looking for your vehicle to repossess it, that has to stop immediately as soon as that case number is issued. Same thing with wage garnishment, collection suits. There are lots of people that call our office that they've gotten a notice from a sheriff. They've been served with a collection suit and they don't know what to do. And we do an evaluation. We're like, look, this isn't your only debt. Bankruptcy is probably a good option for you. And instead of having to respond to that lawsuit, they can file bankruptcy because it stops that collection. They cannot proceed with that lawsuit. They cannot get a judgment. They cannot get a wage garnishment. So it's very important to know that the bankruptcy automatic stay is what you want because that's what stops everything. Also stops all the calls and letters too. So the stay does go into effect, and this is probably going into more legal detail than needed for this, but the stay is not going to be the same in every case. If you are a repeat filer, the stay is not going to be good the entire time. So for anyone's first case that they file, that automatic stay goes into effect the day your case is filed, and it stays in effect until your case is over. Now, a creditor can file a special motion if they feel neglected and aren't being paid to be able to, for example, come get a vehicle again. If you're not making car payments, they can file a motion with the court and say, look, we know the stay is in effect, but they're not doing what they said they would do in their plan. They're not paying their payments. We'd like to lift that stay and come get this vehicle. But for the most part, if your first time is filing, you will have that stay the entire time. Now, if you have filed a second case within a 12-month period, you are in a difficult situation because your stay is technically only going to last for 30 days. You need to have a special motion before that 30-day period is over to extend that stay for the duration of your case. And again, just like in a first-time filer, if a creditor wants to file a motion to say you're not complying with the terms of your plan or not making payments like you're supposed to, they can file that motion for relief. Now, the most difficult case is a third case within 12 months because there is no stay in place. Once you have filed the third case within a year, that's not going to stop the foreclosure sale that's set the next day. Now, there is, some legal recourse that you could do through an attorney to try to have a stay put in place, but it's a very big challenge. I would definitely recommend not putting yourself into one of these situations. But it's very important to talk to a lawyer or talk to a legal aid attorney, anyone, before you start doing these filings, because there is a limit to how many times you can file. And the reason we have this is because the court does not want there to be serial filings. The court doesn't want to have people filing over and over again. That prejudices the creditors because they put out money to get these foreclosure sales. They put out money to get these wage garnishments. So if you're just filing and stopping them, every couple months, that's going to not last very long. All right, so what property can you keep in bankruptcy? One of the biggest fears that I hear from bankruptcy consultations is, I'm going to lose everything. I don't want to file, I'm going to lose everything. And that's just not true. In Louisiana, we have a lot of exemptions that protect the things that are most important to us and the things that are required for our everyday life. So all of your household goods, all of your clothing, all of your appliances, the things that you need, those are going to be exempt. Now, antiques are not exempt. Heirloom jewelry is not exempt. Your wedding ring is exempt if you're married. But that fur coat that you have, probably not going to be exempt. It's a luxury item. So the things that you need are going to be safe. Also, a really great exemption that we have in Louisiana is retirement. All retirement is exempt in Louisiana. So if you have money in retirement and you're questioning, should I take this money out and pay this debt, or should I file bankruptcy? I would probably recommend filing bankruptcy because your retirement is untouchable. Also, we have an exemption for homestead. It is $35,000 in your property. And we also have an exemption on a motor vehicle up to $7,500. Now, that's one vehicle per household, which can get a little challenging if we have, a married couple and each person has a car. But if you have a loan against your vehicle and there's not more than $7,500 of equity in that vehicle, then it's also considered safe and protected. Now, non-exempt things are things that the trustee would sell, those antiques, those collectibles. If you have multiple vehicles that are paid off, if you have a golf cart or a boat, those are things that the Chapter 7 trustee would sell. And those are things that the Chapter 13 trustee is going to say have a value that represents a value that needs to be paid to your creditors. But for the most part, if you need it to live, you're going to be able to keep it in your bankruptcy. And with the right planning, you can usually keep everything. So when we think about which chapter of bankruptcy we're going to file, one of the biggest hurdles that we have to overcome is what's called the means test. If you've looked up anything about bankruptcy, you've probably heard someone talk about the means test at some point. The means test is just a mathematical formula to determine what your income is and where it falls in relation to the median income for your household size in your state. So when we're trying to calculate this number, we're strictly looking at the last 6 months of your income, not including the month we're in. We take the average of that, we multiply it by 12, and we compare that to the median income from your household size. Now, if your income is above that number, and it's substantially above, then you do not pass the means test. You cannot file a Chapter 7. You would have to file a Chapter 13, and there's going to be a further calculation done to determine exactly how far over that median income number you are, and that's going to represent a minimum payment that has to be made in your Chapter 13 case. Now, if you're below that median income, then that means you pass the means test, and you can either file a Chapter 7 or you can file a Chapter 13, and your Chapter 13 has a commitment period of 3 years. You don't have to commit to the entire 5 years. It's also important to note, and this isn't something that we see a whole lot, but there are exceptions to the means test. If you, for example, have a majority of non-consumer debt, meaning your debt is not for your basic family and personal needs. The majority of your debt is maybe taxes or business debt. Has to be the majority of your debt, more than 50%. If that's your situation, you don't actually have to take the means test. And so you might be able to choose between 7 or 13, without having to do the means test. There's also an exception for if you are an active military person and the majority of your debt was incurred while you were in active service or homeland defense. These are not exceptions that we see often, but it's good to know about them in case you qualify for one of those. On this next slide, this is just the median income for Louisiana in case anybody wanted to see it. We actually are getting updated numbers on November 1st. So I have the old numbers from April 1st and the new numbers for November 1st here. You can see for an individual household with one person, the number that we're using right now is 53,677. Starting after November 1st, that actually goes up to 57,923. And I think if that is not a sign of inflation and everything costing more, I don't know what else is. But those are all the different calculations. So if you're sitting there and going, ooh, I don't know if I would qualify, think about how much money you make a month on average or how much you get paid on your paychecks. And you can kind of compare it to this. Now, comparing it that way is not a perfect test because, like I said, we look at the last 6 months of income, not including the month we're in. So I've just put a pretty basic example here where I've broken out the last 6 months. So this would be if somebody was filing on November 1st. As you can see, I put their check stubs. This person gets paid every 2 weeks. So I just put their gross paycheck amount for each paycheck that they've gotten over the last 6 months. We add them all up. Their total over that 6-month period is $17,000. When we take the average of that, it's about $2,800 a month. And so their annual income would be $34,000 for the year. Now, this particular person, if you notice on their paychecks, they had a really big month in June. They had a bonus check for $3,000. So if this person got another bonus check, we would want to pay attention to that because it might affect if they pass the means test or not. So just keep that in mind if you're trying to do your own means test. Do you get paid consistently the same amount all the time? Do you have quarterly bonuses? Are you expecting, some varying income because that could affect if you pass the means test or not? And sometimes it's very important because it could mean the difference between you being in a Chapter 13 for 3 years or for 5 years. So I've mentioned Chapter 7 and Chapter 13, and I waited to talk to them until the end because the other things, the stay, the means test, those are the same for both, but they do different things. So a Chapter 7 is typically referred to as a liquidation bankruptcy, but not everybody has things to liquidate. And most of my clients that file Chapter 7 don't actually have a liquidation case. They have basically just a no asset discharge. So Chapter 7, you do have to be below that median income. And it's typically a 4 to 6 month process. In order to have a smooth and successful Chapter 7 case, what we want is a perfect means test where you pass, and we want no assets that the Chapter 7 trustee is going to sell. Because remember, the Chapter 7 trustee's job is to go through those bank statements and go through those schedules and see, do you have a boat? Do you have money in the bank? Do you have an extra vehicle? And if they can sell those things to pay your creditors, they're going to want to do that. Now, some things that people don't really think about with Chapter 7 is, depending on the time of year that you file, your case consists of everything you're entitled to on that day. So right now we're towards the end of October. So if I was to file bankruptcy today, my tax refund January 1st through October 20th would actually be property of the bankruptcy estate. So if I had some over withholdings or I was entitled to a refund for that, the Chapter 7 trustee could actually keep my case open to wait for me to file my 2025 tax return. And when they review my refund amount, they would take about 10 of the 12 months of that refund. So something to keep in mind if you're thinking about your Chapter 7 and going, I don't have anything, but if you know you get a big tax refund and it's not exempt, which would be earned income credit and child tax credit, you might want to think twice or consult a lawyer before doing something like that. So just to kind of hit on some of the benefits of Chapter 7, the best thing is it is fast, over and done with, usually within a couple months. We are going to get rid of all of your unsecured debt, credit cards, judgments, medical bills, personal loans, all of those things gone. There's no repayment plan. So unlike the other type of bankruptcy I'm going to talk about in a minute, you're not in a plan for years where you have a monthly payment that you have to make. You are in this, you file your paperwork, you're over and done within a couple months, and the only payment you typically make is the one to your lawyer to file the case, or if you're doing it on your own, your filing fee. If you had something in your Chapter 7 that you didn't want anymore, and we do see this a lot, people take out car loans that they eventually realize are a little too much, or maybe that house was damaged in the hurricane and you just can't keep up with it. The Chapter 7 does allow you to walk away from that item. It happens a lot with vehicles, it happens with properties, it happens a lot after divorces. You just need to get yourself off of this particular item. Chapter 7 will allow you to do that, and you no longer have to worry about them coming after you for a deficiency claim or suing you later for the balance of that. The debt is discharged. And Chapter 7 also is usually a little cheaper. So cheaper, faster, gets rid of debt. If you can qualify for it, it's a good option. Now, when we think about who shouldn't file Chapter 7, we want to tell people who have assets to stay away. And as I kind of mentioned with the tax refunds, there are lots of things that people who are not attorneys or don't deal with this every day that they wouldn't think about as being assets. One that we see a lot is pending lawsuits. So have you been in a car accident? It's not because I want to be your big check lawyer. It's because if you have a big check lawyer that's going to be trying to negotiate that settlement for you, when you file Chapter 7, the Chapter 7 trustee can actually take control of that matter and basically settle your lawsuit for you. And you're probably not going to get the money from that lawsuit because they're going to want it for your creditors. So we always make sure if you have a lawsuit or a class action claim or any kind of litigation going on that you think is going to benefit you, you really want to make sure you know exactly what the expectations are on that lawsuit, because a Chapter 7 trustee can step into that lawsuit. And even after your Chapter 7 is over, if those rights existed at the time you filed your Chapter 7, it can pop up again later on. We've actually had that happen for several people with the 3M earplug claims that had claims prior to filing. We didn't even really know they were claims at the time of their Chapter 7. The cases can be reopened because they were existing claims at the time of the bankruptcy. Another big one that we see a lot here in Louisiana is unresolved succession interests. So the common way this comes up is someone says, oh, well, my mom died, but it's my dad's house now. Well, if mom didn't have a will, then in Louisiana, her interest passed to her children with her husband having use of the house. Even if you don't open the succession, even if you say, well, we don't want to take that house from dad, you have an interest in that property that has a value in your bankruptcy estate. And a Chapter 7 trustee can sell a fractional interest in a house to a third-party investor. So it's something to be very aware of if that's a possibility or something that could come up in your case. Now, in my experience, if we do have this come up, we can address it several different ways. And depending on the amount of the interest, sometimes it's something that the debtor can set up a payment plan for themselves. But the best thing to do is be prepared before you file the Chapter 7 so that you know if this is something that is going to come up or not. We already talked about anticipated tax refunds being an option, being an asset. And then also money in your bank account on the date of filing. And I know some of you watching this are probably going, well, I'm filing bankruptcy. I don't have money in my bank account the day that I file. But if you file and you have a direct deposit coming in that night, or maybe you already wrote a check to your mortgage company, but it hasn't cleared, that could be considered money in your bank account that the trustee could consider an asset. So Chapter 7 is a great resource for people, but you do want to make sure that you're not hitting any of these kind of red flags before you file. Right, so the other chapter of bankruptcy is Chapter 13. Chapter 13 is the repayment plan bankruptcy. It's also referred to sometimes as the wage earners bankruptcy. It is a repayment plan. Now, when people hear repayment plan, a lot of times they think, well, if I've got to pay everybody, why am I filing this bankruptcy? But not everybody pays all their creditors in Chapter 13s. Most of my clients that maybe could file Chapter 7, but for whatever reason can't, maybe they can't come up with the fee, they can file a Chapter 13 and they will get the same discharge of the unsecured debts in the 13 as they would in the Chapter 7. They're just essentially financing, their fees. But for the most part, Chapter 13 is going to be your repayment plan. Depending on your situation, you're either going to be paying for things that you want to restructure, like arrears on your house or arrears on your car, and the unsecureds will get a certain percentage, which can be anything from 0 to 100%, just depends on your assets and your income. Now, the Chapter 13 is going to be a 3 to 5 year repayment, and that's going to be based on that means test number. So if you are below means, you don't have to commit for more than 3 years. If you're above means, you have to commit for 5 years. If you're below means, you can go 3, or you can go 4, or you can go 5, but you cannot go more than 5 no matter who you are. You make your single monthly payment to the trustee. Payments are made a couple different ways. Attorneys have their own preferences, trustees have preferences, but ultimately the way we look at it in our office is the debtor is the one who has to make the payments, so we want you to choose how you make your payments. There are 3 options. You can send in a money order or a cashier's check every month to the trustee. This is a good method for people who don't have a lot of computer savviness. You can do a wage order, where your employer will get a notice from the trustee and they will take it right off the top of your paycheck. This is a great way because it doesn't cost anything to do it, whereas going to get a money order takes time and takes money. The wage order takes it right off the top, so you can be confident that your payment always is going to be there. And then the third way, which is kind of a newer way, is through a third-party service. We have one in our district called TFS Bill Pay. I'm not sure if all the districts across the state use it, but they may, or they may have their own. And that allows you to set up like online payments, like an automatic draft. Trustees cannot accept money from your check system or a personal check. You cannot send money to them. You can only do it through one of these different ways. Now, the trustee's job as you make those payments is to take that money and pay your creditors in accordance with your Chapter 13 plan. So if you filed your Chapter 13 because you were behind on house payments, and you've also financed your attorney fee in the Chapter 13 plan, and maybe you have a small amount of unsecured debt that needs to be paid, trustee is going to take those payments, and every month he's going to divide it out and pay it out to those creditors until your plan is complete. And again, 3 to 5 years, that's how long it takes. So Chapter 13 does things that the Chapter 7 can't. And that's really the biggest reason most people will choose Chapter 13 over Chapter 7. The biggest one, and the one we see the most often, is saving a home. You get notice of a foreclosure sale, you don't have that amount of money to reinstate your mortgage, you want to do a Chapter 13. It will allow you to take what you're behind on your house and spread it out over a payment period of up to 5 years. This is a great tool for people. It gives you time to catch up on your house. And a lot of my clients, after they've successfully been in their bankruptcy for a year or two, sometimes qualify for a loan modification, and that helps them out too. Chapter 13 also saves your vehicle. So another reason people file, just like you fall behind on your house when times are hard, you might also fall behind on your car. And sometimes if you fall behind on your car too much, they might come and repossess your car. Chapter 13 will actually allow you to catch up on your car or even get it back if it's been repossessed. Now, that being said, I cannot, or bankruptcy cannot, get a house back once the foreclosure sale has sold. Once the sheriff has, declared it's sold, it's sold. We can't undo a foreclosure sale. When a car is repossessed, it's going to sit on a repo lot for a couple weeks until it's actually sold at the auction. Until it's sold at the auction, you can get your car back through a Chapter 13, and that's a really helpful thing to a lot of people because you can't fund your Chapter 13 plan if you can't go to work because you don't have a car. So it's very important in Chapter 13 for us to be able to do that. Now, the Chapter 13 trustee is not trying to sell any of your assets. So in Chapter 7, that trustee wants to sell things. That's the only way they can recover for your creditors. The Chapter 13 trustee just wants to know what everything is worth so that he can determine how much you have to pay into your bankruptcy plan. But he's not trying to sell anything. He's not going to sell those antiques. He's going to say those antiques are worth $3,000. I expect you to pay at least $3,000 to your unsecured creditors over the course of your Chapter 13 plan. Going back to cars, another interesting thing that Chapter 13 can do that Chapter 7 can't is something called a cram down. So a cram down, I think I'm on the next slide, but a cram down allows you to reduce the balance of your loan to the value of your vehicle. Now, you have to have had your car for a certain amount of time, it's 910 days. If you've had your car that long and it is upside down, maybe when you bought your car, you had some negative equity from a different car loan, or maybe your car has just depreciated. If you put that car into your Chapter 13 and agree to let the Chapter 13 trustee pay the entire car note, you can reduce the balance of the loan to the value of the vehicle. And this saves people thousands of dollars in lots of cases. So another thing Chapter 13 can do is what's called a lien strip. So you took out a HELOC and you really don't have that equity in your house. As long as it's fully unsecured, we can get rid of that and treat it just like an unsecured debt. Chapter 13 also protects your co-signers. So maybe you bought a car with a parent, or maybe you bought a car with a family member and you've fallen behind on the payments, but you want to catch it up. If you put this into the Chapter 13, you'll have the opportunity to catch the vehicle up through your plan, and none of the creditors are going to be able to go after that co-signer while you're in your case because they're protected by something called the co-debtor stay. Chapter 13 allows you to manage priority debts. So debts that wouldn't go away, like child support or taxes, you can set up those in the bankruptcy to repay over time. They don't go away, but it allows you to have, in some cases, an extended period of time to get them paid and make things a little easier for you on a month-to-month basis. All right, so who should avoid Chapter 13? Really, Chapter 13 is a great option for most people, but the only people that we find have a hard time with it are people who just don't have income. Now, just because you don't have a job doesn't mean you can't file Chapter 13, but you have to have some kind of funds coming into the household to support the Chapter 13 payment. Lots of our clients file on disability, they file on unemployment, they file on retirement. We have some clients that file just with support from family members who are helping them, or on domestic support obligations. As long as you have money consistently coming into the household, you can fund your Chapter 13 plan. But if you don't have that, if you have a regular income, if you're not working and you haven't been working for a long time, Chapter 13 is probably not the best option for you. So going over like a comparison of the chapters, Chapter 7, you want to be low income, low asset, very quick, in and out, and pretty much immediate debt elimination. Chapter 13, you can have assets, you can have a little money, you're in a payment plan for 3 to 5 years, but you can also save your house, save your car. If you're behind on your mortgage and you file Chapter 7, the house is ultimately going to sell at foreclosure sale because you're not fixing the problem. Chapter 13 lets you fix it. All right, so one of the things that people tend to, ask when they're thinking about bankruptcy is, well, how do you afford this if you can't afford your bills? Chapter 13, Chapter 7, the costs are actually really pretty reasonable as far as legal representation goes, but also just as far as access to courts go. The filing fee for Chapter 13 is $313. The filing fee for a Chapter 7 is $338. That's across the state. All courts have a fee waiver system that you can qualify for. You have to show that you're below a certain income level, and you have to show that you cannot afford to pay the filing fee in installments. Our court is, very generous with, fee waivers if you qualify, but they're not going to give you a fee waiver if you can afford to pay the fee in installments. And the installments are typically between $75 and $80 for about 3 to 4 months, which is about how long your Chapter 7 case would take. So it's really reasonable to, have that option. Now, there is the credit counseling fee for those credit counseling classes. Remember, I mentioned you have one before filing and you have one after you file before you can get your discharge. The credit counseling classes vary in their fees from $10 to $50. It just depends on which organization you've chosen to go with. I do want to mention, though, if you do qualify for a fee waiver from the court for your filing fee, then you should qualify for a fee waiver from the credit counseling group. And you should definitely mention that to them and say, hey, I qualified for a fee waiver, or I'm applying for a fee waiver, so that you can, take advantage of that. Now, attorney fees vary across the state, but for the most part, most attorneys set their own fees for Chapter 7. All Chapter 7 attorneys, to my knowledge in Louisiana, have to be paid upfront prior to filing the case. And some jurisdictions across the country, they allow for the breakup of fees, but I don't think Louisiana is one of those states. But you could certainly ask your attorney if that was something you were going to do. Chapter 13, most attorneys will allow you to pay the fees over time through your Chapter 13 plan, but you usually do still have to come up with your filing fee up front. Just like any other area of law, there are always pro bono services available through different legal aid groups. And one of the newest things that our court systems have is electronic self-help and self-representation. So if you really good at reading up on all this and you feel like you can do this on your own, there is an ability to do it online too. All right, so this is my little sheet with all of the bankruptcy court websites. They are great resources. Everything you could possibly want to know would be there. And don't ever be afraid to call the clerk's office if you are representing yourself, to ask questions and get directions on some of these things. The clerk's office cannot give you legal advice, but they can direct you to, for example, the Bankruptcy Basics US Court website that also has a lot of information and resources. Or if you were, needing electronic self-representation or copies of forms or list of fees, all of that's on these websites. And I did break up the different districts. So we have 3 bankruptcy districts in Louisiana: Western, Middle, and Eastern. Western has 5 divisions. So these are the different parishes that those 5 divisions service. The Middle District, I have a little map for that one. And then we also have a map for the Eastern District. So if you weren't sure where you're supposed to go find your parish, and that would be your court. All right, so it looks like I do have a couple questions popping up. So if we wanted to do that, I could do that in the next 10 minutes. Let's see.
That would be great. Let me go ahead and read those out to you. The first one we have asks, what type of student loans are dischargeable in Chapter 7?
So student loans that are dischargeable in Chapter 7. So student loans, if you file, they're not dischargeable just on their face. You have to actually have a special proceeding called an adversary proceeding in order to have those loans declared dischargeable. Now, there's actually a new process that's come out in the last year or so called the attestation process, where you open your adversary proceeding and you file this attestation document that lays out basically all of the rules to show why your student loan should be discharged. It's basically, we used to have the Bruner test, which was a 4-pronged, pretty difficult thing to meet. The attestation is not quite as steep, but it is similarly rooted, and you have to basically show you can't maintain a basic standard of living if you were required to repay the, 10-year standard repayment amount, that, you're not having the earning capacity that, you need to be able to sustain a typical life. Also, if there's any outside circumstances, like you were unable to obtain your degree because of injury or health issues, those are all things that go into that attestation. So the attestation works for your federal loans. I have seen in my district where, I've co-counseled on a couple of cases, and we've had a full discharge of federal loans, and we've had a partial discharge of federal loans, and we've had a no discharge of federal loans, for different clients. And as far as the private student loans, once you have gotten whatever your resolution is with the federal student loans, you can use that to negotiate with the private student loans. I'm on a lot of different student loan listserv groups, and there is a lot of activity on private student loans settling with payment amounts, reasonable payment plans, and discharging large amounts of interest and balances. So it is out there, but you definitely want to have an attorney for that, and it does require that separate adversary proceeding, also called a SLAP.
Related to that, we have a secondary question. What are federal non-bankruptcy exemptions, and can we use them in Louisiana with state court exemptions for Chapter 7?
So Louisiana uses Louisiana exemptions. So if there is something that Louisiana does not have a specific exemption for, you can use a federal exemption for that. So I know on my petitions, we use federal exemptions for Social Security and for FEMA benefits. But if you looked at it and said, oh, well, the federal exemption for a vehicle is higher than Louisiana's, you can't do that. You have to use Louisiana.
All right. I'm not seeing any other questions at the moment, but we'll go ahead and give it another minute or so for folks to enter any questions that they might have.
Okay. And I did include in the material some bonus tips for rebuilding credit and also some, common things people do before filing bankruptcy, thinking they're doing a good thing and getting their case ready, and it's really not a good thing at all, particularly doing big retirement withdrawals or, trying to do a home equity loan so that they have some money in the bank. If you're thinking about doing any of these things, my best recommendation would be talk to a lawyer first before you do something. Because, for example, taking out retirement to try to pay things. If you just filed the bankruptcy instead of doing all these different retirement loans, you'd still have all your retirement and have more money coming to you on your paycheck, and you discharge the same amount of debt potentially. So things to talk about, if you're in that situation. Also, another big one that we get, and we see this a lot in Chapter 7, is, your mom lent you some money and you got your tax refund and you paid back mom. You didn't pay back anybody else. So definitely don't want to try to pay family or friends prior to filing, because those could be considered preference payments. And depending on your trustee, those could be things that they go after.
And I went ahead and pulled up the bonus tips you were mentioning so that folks can see those. And then not seeing any other questions, but I am going to go over some additional information. So if you're by chance viewing this presentation at a later date, you weren't able to get your questions or issues answered live, we still have some opportunities for you to get more information. So for additional assistance, you can go to the Louisiana State Bar Association's Find Legal Help page, where you can access a continuum of services that are out there. This includes our attorney directory, the Civil Legal Navigator, legal aid and pro bono organizations like Jenny mentioned. There's also the Modest Means directory and other self-help services. I would like to call special attention to the Civil Legal Navigator. This is a great sort of diagnostic tool that helps you identify your legal issues, and then it provides customized information, referrals to legal aid in your area, and more. It's simple to use. It will give you next steps for your specific issue and or your parish or location. Also, you can access the free legal answers option, which is a online pro bono program that allows users to log in whenever and wherever they like, and they can ask their civil legal questions and have an attorney answer those questions through the website. It's private and it acts almost like an email exchange between the user and the attorney. Please do note, though, that users must meet certain income guidelines to use this program. I do see we got one more question. It is, do you serve the Baton Rouge area? It wasn't listed on the map. Let's see.
Oh, so Baton Rouge is in the Middle District. So Baton Rouge, it's East Baton Rouge, West Baton Rouge, that's Middle District. I do know there are legal aid services in those areas. So yeah. I mean, my office personally, I'm licensed in Middle District, but I don't go there anymore because they're in person for a lot of their things, and my court is by phone. So I'm a little spoiled from COVID. I enjoy doing things remotely, but there are lots of great attorneys in Middle District, lots of great legal aid in Middle District.
Yes, and so to your point, you can use any of these, either the Civil Legal Navigator, the legal aid and pro bono organizations, Modest Means Directory. A lot of these options let you search things by parish. So you can find attorneys in your parish or the district that might be able to assist you. And with that, our next law talks will be tomorrow. So during, like I mentioned at the beginning of this presentation, during Lawyers and Libraries Week, we're doing a law talks every day at noon throughout the week. Tomorrow, the 21st, will be on child custody and visitation. So you can join us here on Facebook at noon. You can also go to the website listed here, louisianalawyersanlibraries.org, if you want to register to participate by Zoom. Jenny, I want to thank you so very much for presenting on this today. You did a really fantastic job of breaking down these complex issues to making them understandable. We got one last question before we sign off. What if you owe taxes? Can you file bankruptcy?
So if you owe taxes, yes, you can file bankruptcy. Now, there's kind of a caveat on that. To file Chapter 13 bankruptcy, you have to have filed your last 4 years of tax returns. So if you owe taxes because you did not file all of those tax returns, you cannot file Chapter 13 until you file those tax returns. You could file Chapter 7 without having those tax years filed, but those taxes are not going to be dischargeable. They are not going to go away. One of our best practices, we always recommend that you have all of your taxes filed prior to filing, whether you're doing a 7 or a 13, because the clock doesn't start ticking until the taxes are filed. And for taxes to be dischargeable, there are several different requirements. The first one is they have to have been filed typically on time. They also can't have been assessed within a certain amount of time, and they have to be for employment tax or like income, and they can't involve any sort of fraud. So if you have tax debts, I would definitely seek out an attorney for help with that and not try to weather that on my own, because the timing is very important. But just because you owe taxes doesn't mean you can't file. Bankruptcy is great for helping people deal with taxes. I have lots of 13 clients that are paying a lower amount in their 13 to deal with their taxes on a repayment plan for 5 years rather than the payment plan the IRS set up for them. So.
Great, thank you. Thank you again, Jenny. I don't see any other questions, so we're at 1 o'clock exactly, so we're going to go ahead and end it. Very much appreciate, like I said, you presenting on this topic. All right, everyone, thank you. I hope everyone has a great day.
Thank you.